Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, a son of Godfrey, the fifth Taliban Jew, son of folk, ruler of Jerusalem. I am the reincarnation of Jesus Christ, which we know as King Edgar the Peaceful, also known as the King of Peace. It is December 12th, 2023, which in the Berber year is 2973. I'm here again with another marvelous lecture for all my subjects, all my family, all members of the Third Temple English Church of England. Once again, it's a marvelous time to be alive, as my Archbishop always says, and it definitely is. With the transition that's about to take place between the exchange of government, which is at its highest point as of right now. So please make way, as we know, for the king, because the king is now back. There is no interregnum. The demise is about to take place right before your eyes. So without further ado, this is another informative lecture on the Cestui, the right to petition the king on behalf of the Cestui, which is the trust that was left for you on behalf of him being the trustee on behalf of that said trust. Today's lesson is going to be another conglomerate of all the previous lectures that I've done, which is pretty much going to be focused around case law. All right, as well as we can go in depth with the history involving that case law to show you that the point in time that it goes back to is the time which we reference in the Third Temple English Church of England as what we call time immemorial. Time immemorial, which means a time at a mind. All right, a time at a mind. You know, a lot of us claim to, or a lot of us say that we know our history and that we're making our journey back to that illustrious past for our present future. But I have not seen any groundbreaking work to bring that state of theory or ideology to fruition, which is a problem for me because for much is given, much is required. You know what I'm saying? So without further ado, I'm coming to show you that which was left for you as English heirs has not been touched, but has been protected by those who are in the position of power, as we know right now, under the term or under the guise which we call the United States of America. All right. So without further ado, let's get busy. All right, where we want to go. Cestui. Once again, we can never talk enough about the Cestui. Wills, trust, and estates. In this case, we're talking about the only true trust is land. Once again, the only true trust that anyone can be associated with in regards to you being the heir is land. All right. We know there is no real money out there circulating and what we call real wealth. So the only wealth that's contrary to that paper wealth is what we call real estate. Okay. Real estate. Real estate deals with real property. All right. Real property. All right. So we need to grasp our minds around the understanding of what it is that we perceive to have in regards to what we call real property, because none of you actually have real property or real estate. You do not have this. All right. Let's validate this. We're going to go step by step for babies, beginners. Cestui is a shortened version of Cestui et use le fifement fiat, the person whose use, the benefit, or fifement was made. In modern term, it corresponds to the beneficiary, i.e., the one who the trust was set up for. All right, the beneficiary. All right, for the use of, the beneficiary use of. All right, it is a law French phrase or medieval English invention. So it is Cestui is a law French phrase that derived from English invention. All right, under the English common law. So the Cestui originates from English common law. We must understand that. We're not going to get into different categories. Just going to the origin and the purpose. All right, this is what's very important. The origin and purpose of a Cestui, because a Cestui is what they say, a fiefment. What is a fiefment? Let's discuss that right quick. Fiefment. In Middle Ages, especially under European feudal system, when they say feudal system, you're automatically going back to the Norman conquest, all right? Or the Norman invasion, going back to the feudal tenures when feudal tenures were given out, which is partial or partial estates and land, all right? Which you know in modern day as a bundle of rights, all right? It says in Middle Ages, especially under the European feudal system, or enfeoffment was a deed. You hear that, y'all? By which a person who gives land in exchange for a pledge. All right? A person who gives land in exchange for a pledge of services. So that means that you become obligated. It becomes contractual agreement based off a pledge. When you pledge something, that means you give up something as a result of an obligation as a result of that pledge. All right? That means the grantor gave the grantee something as a result of what was given by the grant to the grantee. It was a pledge that took place. This mechanism was later used to avoid restrictions on the passage of title and land by a system in which landowner would give land to one person for the use of another. The common law of estates and land grew from this concept, okay? Estates and land grew from the term what we call fiefament. And the fiefament is land given to a person for a pledge, all right? This is the same situation we have in the Articles of Confederation with your new founding government that you now call the United States of America. It originated from a covenant or agreement or a contract which resulted in what we call a pledge that originated from time immemorial, all right? Going back to the Middle Ages, all right? Back to William the Conqueror. All right, let's go back here. Just too quick. The original purpose of a Cestui or a fiefment, which actually denotes to land, a land tenure, feudal tenure, land tenure. In America, there's only three: fee and defeasible, life estate, and fee and simple. Once again, contrast to allodial. Fee and simple is what we call are subject to what we call a process of common recovery through subinfeudation. All right, the selling of somebody's land when the land was not supposed to be sold because the land was entailed. Original purpose of a trust, known as what we call a cestui or fiefment, are rooted in medieval law. So all those who concerned with land law or real estate law or land ownership or what we call right of possession, then you need to go back to the origin of where it originated from, which is the Middle Ages, going back to medieval law, which is a legal device for avoiding feudal services, most forms of servitude, i.e. pledges, due to an overlord by granting the land for the use of another, one who owed none of these to the Lord. Okay? The law of Cestui tended to defer jurisdiction to courts of equity, chancery, or exchequer, as opposed to less flexible common law courts. The vice was often used by people who might be absent from the kingdom for an extended time for prescription, as on a crusade or a business adventure. So in this is interchangeable. A business adventure is what we call a crusade, what we call foreign trade or international trade, or what we call dealing with what we call tariffs. All right. The land could not be left for the use of a third party who did not owe those incidents to the Lord. Any such entrust legal status was partly to circumvent the Statute of Mortmain, which means dead pledge. All right. Statute of Mortmain means dead pledge, which means it never leaves the hands of the church, because the church is a non-natural person. He's immortal. All right. Right here, y'all. Follow along. First, it can be characterized as referring to a deceased donor or a former owner and their desire and their will that the church is inherit. Second, as the church is a non-natural person recognized by the common law, never dies. The land never leaves its dead hand. Okay? The land never leaves its dead hand. The church never dies. The church represents the crown by way of what we call corporation soul. In this case, we're talking about land. So this would, in case point will be what we call crown land. Okay, it's called crown land, and crown land is entail land, which means that it cannot be sold. It cannot be alienated because it's an inalienable, which means it's allodial. It remains attached to the church. All right. Crown land. They're very basic principles that you all must understand. It's all going to go back to Edward I, son of Henry III of the Plantagenet crown. All of it's going to go right back to him. All right. Crown land, sometimes called crown land, also known as royal domain, is a territory area belonging to the monarch who personifies the crown. This is also called the English throne, because if you go back to the Norman conquest, it was a result of Norman's invasion upon the English throne, and the English throne is called the crown, and the crown is the church that protects crown land, because the crown land is entail, which means it's subject to what we call the Statute of Mortmain. And the Statute of Mortmain means a dead pledge. So all the property was pledged in lieu of what we call revenue raised for the king, which we know in English common law is called freeing common soakage. Today in Commonwealth realms, crown land is considered public land and is apart from the monarchy's private estate. So public land goes into the public trust doctrine. Okay, public land goes into what we call the public trust doctrine, which we'll get into in a second. So crown land is entail land, which is personified by the crown. Okay. In Britain, the hereditary revenue of the crown land provides income, i.e., free and common soakage, i.e., revenue, for the monarch until the start of the reign of King George III, when the profits from the crown estates were surrendered to the Parliament of Great Britain, i.e., King and Parliament, in return for a fixed civil list payment. The monarch retains the income from the Duchesses of Lancaster. The Duchesses of Lancaster goes back to Edmund Krausbach, which was the son of which was the founder of the House of Lancaster. Okay, the Duchess of Lancaster. Let's get a preview of that real quick before we move on. The Duchess of Lancaster, as you can see. You see the three lions. Let's just go to the origin. History. As the Lancaster inheritance, the estate dates to 1265. when Henry III granted his younger son Edmund Crouchback lands forfeited by Simon de Montfort, Earl of Leicestershire. Okay, so the lands forfeited from Simon de Montfort was given to Henry III's son Edmund Crouchback. All right, who was the founder of the Lancaster branch. Okay, he was the founder of the Lancaster branch. Everybody see that? All right, this name Edmund Crouchback is going to come back up again in case law. Okay, it's going to come back up in case law. Mind what I'm telling you. Let me just make sure. What is that? Let's see. Let's get to it. Edmund Crouchback. Edmund, Earl of Lancaster, also known by his effort, Edmund Crouchback was a member of the Royal Plantagenet and the founder of the first House of Lancaster. All right. Named after the 9th century saint, Edmund was the second surviving son of Henry III of England and Eleanor of Provence, and the younger brother of King Edward I of England, who will be referencing case law today. All right. To whom he was loyal as a diplomat and warrior. Okay, so there you see Edmund Crouchback was the son of Henry III. All right, and Henry III was the son of who? Henry III was the son of Henry II, parts of John. Just make sure. Yeah, John. Okay, you got to know your family line, y'all. Got to know your family line. Right there. Plantagenet House, John, his father. Okay? Crown, let's go back to Crown Land. It said Crown Land is Intel land. Didn't it just say that? It's a territory area belonging to the monarch who personifies the crown. How do you personify? Everybody know what personify means, right? Let's define personify. To conceive or represent as a person or as having the human qualities or power. To be the embodiment or personification of or to incarnate. To incarnate, or in this case, in the concrete will be incorporate. All right, contrast to unincorporated. Corporate on contrast to unincorporated. Very, 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 very important to understand that concept when we make a reference to concrete points of law or facts. That's not presumptive. All right, very important. So it's the crown land is personified by the crown. And we know the crown is a corporation soul. Not a non-natural person, because the church is a non-natural person. The crown is a natural person. All right? Because the king personifies the crown by the office that he holds. All right? And what we call jure regalia. The crown is a state in all its aspects within the jurisprudence of a commonwealth realm and their subdivisions. When we're talking about radical title, dealing with the overseas territory, provinces, and states. These terms can be used to refer to the office of the monarch or the monarchy as an institution to the rule of law or to the function of executive, crown and council, legislative crown and parliament, i.e. king and parliament under the royal prerogatives, and judicial crown on the bench, i.e. king and bench. The concept of the crown as a corporation soul developed first in the Kingdom of England as a separation of the physical crown and property of the kingdom from the person and personal property of the monarch. It spread through English and later British colonization and is now rooted in the legal lexicon of all 15 Commonwealth realms. Did y'all hear that? The term is also found in various expressions such as crown land. which is some countries refer to as public land or states land, or what we call the public trust. All right? The public trust. Let's go back to the Cestui. First crown land. Let's go back to crown land. Now it says it's entail. What is entail? I've been through this already. If you're not up to speed with this, then you pretty much lost in the sauce. In English common law, fee-tail or entail or tellalize is a Scottish law and a form of trust established by the deed or settlement, i.e. a charter, that restricts the sale of inheritance and of estate in real property, not fake property, or what we call paper wealth, and prevents the property from being sold, divided by will, or otherwise alienated by the tenant in possession, and instead cause it to pass automatically by operation of law by way of disposition. All right, reversion of estate or remandering of estate to an heir determined by the settlement deed. The settlement deed is that charter, i.e., that deed, i.e., that freefament called what? Everybody take a shot at it. What's it called? It's called the Cestui. Why? Let's go back to it. It's called the Cestui. Cestui. Any such interest legal status was partly to circumvent the Statute of Mortmain. All right? We know Statute of Mortmain was passed by who? Edward the First, with two enactments in 1279 and 1290, passed in the reign of Edward the First of England, aimed at preserving the king's revenues. Revenue deals with raising taxes. All right? International trade contrasts with domestic trade because international trade was governed by the church, i.e., the crown. All right? I.e., the corporation soul, which is a natural person, contrast to a non-natural person, i.e., a legal fiction, based off of the estate, i.e., crown land being entail. We know entail estate is a contrast to fee and simple estate. All right? You better understand these concepts I'm telling you, because case law going to verify it. The two concepts explain the origin of mortmain, which means a dead hand. First, it can be characterized as referring to the deceased donor and former owner. In this case, it will be God to y'all. All right? This will be God in the abstract world. To us, it will be the king, because king represents God, i.e. the Lord. The two concepts explain the origin of mortmain, dead hand. First, it can be characterized as referring to the deceased donor and former owner of their desire and their will that the church inherits. Second, as the church is a non-natural person. All right? So a non-natural person is not a natural person. What's a non-natural person? And law, a legal person is any person or thing that can do the things a human person is usually able to do in law. Did you hear that? Such as enter into contract, sue and be sued, own property, and so on. These are called corporations. Contrast to corporation soul. Y'all better understand what I'm telling you. These are called legal fictions, corporations contrast to a corporation soul. All right? A non-natural person recognized by the common law never dies, that never leaves its dead hand. Before that means that if legal persons are non-natural persons, that means that you are also crown property. All right? You are crown property because you are an heir that's assumed to be dead and gone. All right? So all you as property has been pledged back to what? The crown, by way of you being part of the entail estate, right? Which cannot be sold, transferred, alienated to anyone, right? It says here, before this act, vast tracts of land were left directly to the church, which never relinquished it. You hear that? Church never relinquished it. Which church was this? The English church, contrast to the Church of England under the Roman Catholic Church, under the Roman Catholic diocese, under the bishops who run the Roman Catholic diocese, going back to Pope Gregory I and Archbishop of Canterbury. All right? St. Augustine of Canterbury. Hence the word Augustine. Other lands could be transferred to anyone inherited only through a family line, sometimes called the male line, okay? Or revert to an overlord or the crown upon the death of the tenant. Church land has been a source of contention between the crown and the church for centuries. So they talk about three things: entail estate, fee simple estate, and if there is no entail fee simple estate, that means that it automatically ceases and reverts back to the crown, as it just said right here. Reversion or remandment. Reversion is a property law in future interest, not past, not present, for future interest that is retained by the grantor after the conveyance of an estate of lesser quantum that he has. Once the lesser estate comes to an end, i.e. time run out, end of the contract, the property automatically reverts back to the grantor by what we call statute of dispensation. All right? I don't understand what I'm talking about. You will by the day. Transfer to anyone. Inherited only through the family line. So to be transferred to anyone is what they call fee simple. How we know? Let's look at it. I just clicked it. Let's go back. Y'all see it for yourself. Transfer to anyone means what? Now we know crown land cannot be sold because crown land is entail. Why? Because it's a pledge to the church, and the king represents the church. Now, but what church is we talking about? Because the English church is represented by the corporation soul, contrast to a corporation, which is an aggregate, which is a spook, a legal fiction, a thing. And English law, transfer to anyone denotes to alienation, subrogation, which in this process is called English law, a fee simple or fee simple absolute. It's an estate in land, a form of freehold ownership. That's why you got freeholding. A fee is a vested, inheritable, present possessory interest in land. Possessory interest, i.e. prescription, all right, in land. A fee simple is real property held without limit or time under common law, whereas the highest possible form of, let's go here. The highest possible form of ownership is a fee simple absolute, which is without limitation on the land use. Such qualities or conditions that disallow certain uses of the land are subject to vested interest or termination. These are encumbrances, all right? These are called encumbrances, all right, as a result of the easements, all right? Easements are by what we call prescription, a non-possessory use and property that you don't own. The right of fee simple owners are limited by the government by way of what we call its police powers through the power of taxation, compulsory purchase, police powers, and it's cheap. What happens when land is cheap? It means there are no heirs. And may also be limited further by certain encumbrances or conditions in the deed, such as, for example, a condition that requires the land to be used as a public park with a reverted interest in the grantor and conditions fail. This is fee simple condition. Did you hear that? In common law. In English common law, the crown has a radical title or the allodium of all land in England, meaning that it was the ultimate owner of all land in past feudal eras, allodial title reserved to the government under a civil law structure. However, the crown can grant ownership in abstract entities called an estate in land, i.e. parcel of land or partial land, which is what is owned rather than the land it represents. The fee simple estate is also called estate fee simple or fee simple title, or sometimes simply freehold in England and Wales. Did you hear that? All right. From the start of the Norman conquest, the Norman period, when feudalism was introduced to England, the tenant or holder of a fief meant, i.e. a trust, cestui, could not alienate it, sell it from the possession of his overlord. However, a tenant could separate or parcel of the land and grant it as a subordinate fee to his own subtenants, a process known as self-enfeoffment or subinfeudation. The 1290 Statute Quia Emptores abolished subinfeudation and instead allowed the self-fee simple estate. Did you hear that? Did y'all hear that? William Blackstone's qualifying that right here. Those who are looking at this, you can read it on your own, but for the sake of time, since it's talking about statutes of mortem, what it says, Quia Emptores. Quia Emptores by King Edward III. Let's go back to what we call the Cestui. Right here. So we know transfer to anyone is fee and simple. So what is the opposite of being transferred to anyone, i.e. called fee and simple? Let's look at the contrast one. It said inherited only through a family line. So which one is that? That's fee and tell. And English common law, fee, tell, entail, or tellalide in Scottish law is a form of trust established by a deed or settlement that restricts the sale or inheritance of an estate and real property, prevents the property from being sold. All right? Sometimes to a male line, i.e. primogeniture, birthright. Did you hear that? If there is no male heir, that means that it is steeped as a result of the no heirs, and it automatically reverts back to the crown under what we call reversion or remandment of what we call the estate. All right? Reversion or remandment of the estate. We must understand what's going on. All right? As we see here. The Doomsday Book. The Doomsday Book referred to guilds or money sacks and stocks held at opus regis for the use of the king, of the queen, of the viscounts. The laws of William the Conqueror, i.e. William of England, speak of the sheriff holding money for the use of the king. All right, we all see that. Go a little further. Medieval invention. Many reasons have been given for the inventions of the Cestui. This is the most important part y'all need to understand about the concept of this trust or Cestui or fiefment, i.e. land tenement given by the monarch in lieu of the heirs who are now considered what we call interstate, which means that they assume that we're not here anymore. So it automatically speaks to either the crown or bona vacatina, the state who now possess the power of the crown as surrendered to what we call the United States as under the Articles of Confederation. All right. It says many reasons have been given for the inventions of the Cestui as a legal device, an instrument. During the Crusade or the business adventure in other wars on the continent, landowners might be gone for a long period of time. This is in the case of the English heirs and successors. Others might be absent because of business adventure or religious pilgrimage, such as the case of the Englishmen. There was no assurance that they would ever return home. The Cestui use allowed them to leave a trust, friends, or relative with the sort of powers, discretion, and they hope the duties. You hear that? This is where the church comes in. Today, these powers will be called the powers of the attorney. All right? Power of the attorney. Religious orders such as the Franciscans, Cistercians, Benedictines, and other mendicant orders took vow of poverty, yet retained use of donated property. Cestui use allowed them to benefit of land without legal ownership. So they were the caretakers of the properties. These so-called monastic orders, known as the Franciscans, Cistercians, Benedictines, and whatever else is out there. All right. We know the Franciscan order goes back to what we call the Holy Order of the Holy Sepulchre, going back to what we call what's the name? Godfrey what's his name? Godfrey Bullion. And Godfrey of Bullion was protector of the Holy Sepulchre, and which was founded by Saint Francis I. All right, Saint Francis of Assisi. All right, which is responsible for the Franciscan order. So you got the Cistercians and the Benedictines and the Midlands order. These are what you call the doctrines of the doctrines of the church, or the doctors of the church. All right, or what they call the church fathers. All right, the church fathers. all under the authority of the Roman Catholic Church, going back to St. Augustine of Canterbury in 597. All right, for Pope Gregory I. Besides the obvious limitations placed on the Cestui by the Statute of Mortmain, the Statute of Uses, and the Statute of Wills, its legality was shaped indirectly by provisions within the Magna Carta and Quia Emptores. The Magna Carta was created by John. John was the son of Henry II, the son of Godfrey the Fifth Calabrian Jew, and lieu of Quia Emptores. Quia Emptores was the law passed by Edward I, who said that intel estates cannot be sold or subjugated. All right. Instead, they fall under the jurisdiction of the Statute of Uses and the Statute of Wills, as issued by King Henry VIII of the House of Lancaster branch, who usurped the English Church of England. All right. Who usurped it. All right. So all the property that belongs to the church through the Statute of Uses and the Statute of Wills, as ordained by the Statute of Mortmain and the Queen of Emptores by Edward I, but preserved by King Henry VIII of the House of Lancaster through the House of Tudors. All right, which resulted in what we call the Cestui. All right, the Cestui, which we're on right now. Henry VII, y'all see him right there, founder of the House of Tudors, and Henry VIII. All right, all from the Lancaster branch. All right, all from the Lancaster branch. And we know they all descended down from who? The Duchess of Lancaster, which was founded by who? Edmund Crownsback. Once again, Edmund Crownsback. All right, in lieu of the king's revenue, in lieu of what we call crown land, and crown land is crown property. Why? Because it's intel. All right, it is intel. We must understand that concept. All right. So as I said here, those who were left in over in charge of the trust as power of attorneys descended down what we call the Franciscans, Cistercians, Benedictines, and other Dominican orders. All right, we know that goes back to the once we go, as we said, to the Holy Sepulchre. All right, the Holy Sepulchre, going back to the concept of Jesus Christ. All right, the death of Jesus Christ. All right, all that's covered by the Franciscans monastery stories that were told in lieu of these events that are in question. All right, all of those are told by these concerning what we call the doctrines of the law. So, what are the doctrines of the law, or the doctrines of the church, i.e., church law, i.e., ecclesiastical law? Very important. Because it all involves the overseeing of the trust. All right? It all oversees this overseeing of the trust. You know, the trust deals with the estate, and the estate is land. All right? Is land. So we're going to start in the 16th century. All right? We can't depend on those in the and going back to time immemorial, going back to Ambrose, Augustine of Hippo, and Jerome, because all these were validated by Pope Boniface VIII. All right, in the 12th century. This is when the honoring of the doctrines of the church came into existence by Boniface VIII, the Pope of the Pope, Roman Catholic Pope. All right, from the Roman Catholic Church, going back to Pope Gregory I, who had all the Anglo-Saxon converted to Christianity by St. Augustine of Canterbury. All right? Let's pull that up right quick. Gregorian mission. We're talking about the church fathers or the doctors of the church. Excuse me. $597. All right. Now Pope Gregory the Great under had Augustine of Canterbury convert all the Anglo-Saxon Berbers to what we call Arianism, which is the Christian religion. All right. We know Pope Gregory the First had all the barbarians under the Arianism religion honor the origin where they came from, dealing with the Lombards, the Frankish, and what they call the Visigoths, which was all Northmen, all Vikings. All right. Everybody pull that up. All right, I'm back. All right. Gregorian mission. The Gregorian mission or Augustinian mission was a Christian mission sent by Pope Gregory the Great in 596 to convert Britain's Anglo-Saxons. The mission was headed by Augustine of Canterbury. By the time of the death of the last missionary in 653, the mission had established Christianity among the southern Anglo-Saxons. Along with Irish and Frankish missions, it converted Anglo-Saxons in other parts of Britain, as well as the influence of the Hiberno-Scottish mission to continental Europe. This involved the Norman conquest and what we call the Norman conquest and the Norman conquest of Italy. All right, this existed. This you had one in the 10th century, and you had one in the 9th century. They actually were synonymous. They were both occurring simultaneously. All right. So all the Anglo-Saxons were converted to Christianity by Pope Gregory I. And Pope Gregory I was considered a doctor of the church. All right. He was a doctor of the church. And this was the time when Anglo-Saxon was living in tribes and under what they call Ethelbert of Kent. All right. The House of Wessex is not in existence at this time. It's going back to Ethelbert of Kent. All right. It's going back to the legends and myths. All right. So once again, Anglo-Saxons were converted to Christianity by Pope Gregory I. Pope Gregory I or Pope Gregory the Great, as we'll read here. Gregory gained papal authority, all right, in Spain and France, all right. So the Kingdom of Spain and the Kingdom of France was under the papal authority, all right, under Pope Gregory I, and sent missionaries to England. When we're saying going back to the time immemorial, dealing with the conversion of our ancestors to Christianity through Arianism under the Spanish and Frankish influence, that means that not just over there, but as well as over here, because you had the Spanish kingdom and the Frankish kingdom over here, known as New Spain and New France, going back to the origins of Old Spain and Old France, going back to origins and the conflicts going back with those in England, all involving the so-called trust. All right. Gregory gained papal authority in Spain and France, not in England, and sent missionaries to England, including Augustine of Canterbury and Paulinus of York, to realignment of barbarian allegiance to Rome from their Arian Christian alliances shaped medieval Europe. Gregory saw the Frankish, Lombard, and Visigoths aligned with Rome in religion. He also combated the dynastic heresy, particularly in North Africa at the time. This gets into what we call St. Augustine of what we call Hippo, all right, which was also a member of what we call the church. All right, let's get to it. So we see the Gregorian mission. Pope Gregory I had all the Anglo-Saxons converted to Christianity by St. Augustine of Canterbury, all right? Augustine of Canterbury. So we know that the doctors of the church before the 16th century in the Western Church, four outstanding fathers of the church attained this honor in the early Middle Ages. Gregory the Great, Ambrose, Augustine of Hippo, and Jerome. The four doctors became a commonplace notion among scholastic theologians, and the decree of Boniface VIII, 1298, ordered their feasts to be kept as doubles throughout the Latin Church and contained in his sixth book of Decretals. All right? So the four doctors of the law, which consist of Ambrose, Augustine of Hippo, and Jerome, and Pope Gregory I, was first authorized by Boniface VI, who participated in what we call the Scottish independence. All right, in 1296. How we know that? All right. First of all, Augustine of Hippo was a Berber. Augustine of Hippo, origin of Bishop of Hippo's Regis in Normandy. He was from Hippo Regis. All right. Roman North Africa, writing influenced the development of the Western philosophy and Western Christianity. All right. Everybody looked up at their own time. All right. He was one of the popes of the list of popes going all the way back to St. Peter. All right. Which Christ said he'll build his church off. All right, going back to the 1st century. Augustine of Hippo. Was born in 354 AD. All right. 354 AD. Everybody see that? Augustine of Hippo. We know that Augustine was one of the protectors of the Cestui, as they stated, right? The Augustinians, then the Benedictines. It said it right here. Well, I didn't say the Augustinians, it said the Franciscans, Cistercians, Benedictines, and other Dominican orders. But the Augustinians were one of them. All right, they were one of them. All right, who protected the so-called Cestui. I'm going to prove it. All right, Augustine of Hippo. Augustine of Hippo, also known as Saint Augustine, was a theologian and a philosopher of Berber origin and the bishop of Hippo Regius in Numidia, Roman North Africa. His writings influenced the development of Western philosophy and Western Christianity, and his views as one of the most important church fathers of the Latin Church in the patristic period. All right? He existed in 354. The first one was mentioned was who? Was Ambrose. Well, Gregory the Great. Let's go to Ambrose. He was born in 374. I mean 304, if I'm not mistaken. Born in 339. Okay. Born in 339. This is another church father. Ambrose of Milan. So we know St. Augustine of Hippo was born in 597. Ambrose of Milan was born in 339. All right. 339 AD, Annus Domini, in the year of our Lord. All right. And he was a church father. They also mentioned who else? Jerome. He born in 304. (342). He's born in 342. Everybody see that? Church fathers. Jerome, Ambrose, Pope Gregory I, and St. Augustine of Hippo. All right? St. Augustine of Hippo. So let's go to the year 339. AD, Annus Domini. Why is this important? Because, you know, Pope Gregory I descended from Pope Gregory XIII, which had all the calendars changed, which was descended from the Julian calendar. We know that in uh, uh, 1582 is where the Gregorian calendar existed, so there could not be a 339 AD. All right, because at that time they were using the Berber calendar, and in the Berber calendar we see the year with what we call 1289. Okay, the year is 1289. At the year 1289, they said Aurelius Ambrosius, Italian bishop, theologian, was born. But at this same time, under the Berber year, guess who's reigning? King Edward I. What is the year? 1289? 1289. Everybody see that? The Berber year is 1289. All right. Let's look up the year 354. The time of Augustine of Hippo. These are very important. 354 AD. The Berber year is 1304. Once again, in 354 AD, the Berber year is 1304. Okay, 1304. So what year is it in 1304? Who's ruling in 1304? Let's see. Well, I got it here already. Everybody see that? Edward the First, from 1239 to 1307. All right. He's King of England. He's the son of who? Henry III of the Plantagenet crown. All right. Of the Plantagenet crown. All right. When Scottish got their independence from England, it was in 1295 through what we call the First Scottish War of Independence. We talked about that already. All right. The Scottish War of Independence. All right. Let's go back to Boniface VIII. The ones who created the doctrine of the church fathers. All right. Dating back to Pope Gregory the First. Okay. Boniface VIII put forward some of the strongest claims of any pope to the temporal well as spiritual power. He involved himself often with foreign affairs, including France, Sicily, Italy, and the First War of Scottish Independence. All right? All right? Let's go right here. Just to prove it. He had something to do with Duchess of Lancaster with Edmund of, what was his name? Krausbach. Where is it at? This goes back into the Norman conquest through what we call the East and West schisms between the churches, the war between the churches. It says right here. On the 26th of February, 1265, only 11 days after his coronation, new Pope Clement IV wrote to Cardinal Simon telling him to break off negotiations and travel immediately to Provence, where he would receive further instructions. On the same day, Clement IV wrote to Charles of Anjou. Charles of Anjou was from the House of Anjou of the Capetine dynasty, who was warm with the Plantagenets dynasty. All right. Wrote it to Charles of Anjou, informing him that the Pope had 35 conditions that Charles must agree to in accepting the crown. He also wrote to Henry III of England and his son Edmund Krausbach that he had never been possessor of the kingdoms of Sicily. The kingdom of Sicily goes back to the Norman conquest of what we call the Norman invasion. What was the name of that? It was called. I have it here. It's called the Norman conquest of southern Italy. Once again, it's called the Northern the Norman conquest of southern Italy, going back to the kingdom of Sicily. All right. This involved Æthelstan, the son of Æthelwold the Unready. All right. This was before the Norman conquest of England. All right. Because the Normans were invading everywhere. They were invading everywhere. All right. So as we can see here, that the Roman popes or the church fathers going all the way back to Pope Benedict the Eighth, who descended down from Pope Clement the Fourth. Pope Clement the Fourth was reigning. There were 7 popes that succeeded Pope Clement the Fourth prior to Pope Boniface the Eighth coming upon the throne. I think it was like eight popes. All right, because there was a list of popes going back to Saint Peter, the first pope, which Christ said he built his church, and which the church fathers are sending down from. All right, let's see. So as I said, Cestui. The religious orders, such as the Franciscan, Cistercian, Benedictine, and other Benedictine orders, took vow of poverty and retained the use of the donated property. All right, maintained they were the trustees over the so-called estates and lands as a result of the business adventures of the heirs in regards to the status that they are in now. All right, because right now their condition is a result of what we call business adventures by way of them being classified as what we call corporations. All right, and as corporations, you are considered what we call property, and when your property abandoned, that means that the only person that can claim you in English law or English common law is the crown represented by the king. If not, then that means that you are property of what we call the states, all right, which oversees the property, what we call bona vacatina, all right. It's under what we call the crown. We'll go there in a second. So we see the Franciscan orders, you had the Cistercian orders, and we have the Augustinian orders as well. Besides what we call the Benedictine, because the Augustinian orders go back to what we call the doctors of the church. And we know one of the Augustinian doctors of the church was St. Augustine of Hippo, a Berber, all right? And the Augustine of Hippo, a Berber, goes back to the list of popes, going back to St. Augustine of Canterbury of 597, who had all the Anglo-Saxon Berbers converted to what we call Christianity, the same Christianity that was taught by St. Augustine of Hippo. All right, we must understand what is going on. All right, what is going on. So in order to understand that, we just go to a list of what we call list of popes. Or doctors of the church, or we call it church fathers, which was came upon the scene until Boniface the Eighth, the Pope Boniface the Eighth. All right, backdating all these popes, going all the way back to who? Saint Peter. All right, let's go here. If you go back to the first millennium, all right, the first millennium, you'll go back to what we call Peter, or what we call Saint Peter. We see it right here. Saint Peter. All right, let's first pull up 1 AD. I'm trying to teach y'all. 1 AD. 1 AD, and the Berber year will be 951. All right, everybody see that? 1 AD, and the Berber year will be 951. We must see that. So the Julian calendar, AD, or the Gregorian calendar, 1 AD, will be in the Berber year, 951. All right? Let's go back to 950, or 1 BC. 1 BC. I've been through this already, but apparently some of you don't get it. He who writes your books sets a timeline. Time never was when man was not. It's the life of time when man began, the time will come where we will be no more. 1 BC. Okay? So in the Berber year, there is no change from BC to AD. The years are still corresponding to the next year repeatedly. 950 AD, 951 AD, 952 AD, and so on. All right. But yet, under the Gregorian year or the Julian calendar, you get a move from 1 BC to 1 AD. All right. From 1 BC to 1 AD. All right. That means different epochs now are taking place. When in the Hebrew calendar, God is just creating the world in 3761. The world is just being created in the Hebrew calendar. So what's wrong with that picture? We must understand what's going on. They're messing with your timeline. All right? They say right here, the religion estimated time of birth of Jesus, and the Christian religion as assigned by Dionysius Exiguus, pardon if I pronounced that wrong, and his Annals Dominios, according to most scholars. They also use the word incarnation, i.e. personification, as we see it in what we call the word or the term corporation soul. But it is not known whether he meant conception or birth. However, at least one scholar thinks Dionysius placed the incarnation of Jesus in the year 1 AD. And we know the year 1 AD is the year 1 BC. 1 AD is the year 951. Annus Dominus. Annus Dominus, the year of our Lord. So the Lord is here on earth. The term and before Christ are used with designated year. 1 second. Let's see here. 951. All right. Year 951. All right. So when you go back to the church fathers, all right, and you go back to the list of popes under the church fathers, you go back to St. Peter. All right. Jesus said, upon this rock, I'll build my church. Date and place of St. Peter is 1 AD. And we know in the Berber year, it's 951. All right. It is 951. All right. We know that the Roman Catholic Church are said to be the protectors or the trustees of God's church because on their logo they represent St. Peter's keys, the keys of heaven and earth, or the keys of the kingdom of heaven. Y'all need to understand what's going on. So if all this was kept secret by the doctors of the church, and the church fathers were not put on the scene till Pope Boniface of the eighth, right, in the 12th century, all right, and he was associated with the Scottish independence, and the Scottish independence is associated with the Scottish kings, the one who wrote the so-called Bible at the time of the creation, which is also at the time of 1 AD, 3761, according to the Hebrew calendar, which is not the same as the Berber calendar or the Julian calendar. Totally three different calendars that are played at that time, but speaking simultaneously. Just as was all the other calendars. All right. And we know 1 AD is, according to the abstract story, it's where God built his church or Jesus built his church. So, in a concrete story, in lieu of God's church being built, in lieu of a concrete understanding, we must go to the Middle Ages dealing with St. Peter, which brings you to the Church of New Ministry, which will bring you right here. New Minister's Charter. The New Minister's Charter is an Anglo-Saxon illuminated manuscript that was likely composed by a bishop of Æthelwold and presented to the new ministers of Winchester by King Edgar in the year 966 AD to commemorate the Benedictine reform. It is now part of the British Library of Collections. Did y'all hear that? Did y'all hear that? Let me take it to the picture. As you can see here, King Edgar, St. Peter, and Mary, flanked by angels, Jesus Christ, but the new minister's Book of Vitae, Book of Life, which is closed. All right, Liber Vitae, Book of Life. All right, it's in this depiction, it's closed. All right, and King Edgar is presenting the charter to the image of Christ, the personification of Christ, the incarnation of Christ. All right, the incorporation of Christ in that seat or that office as king in parliament or king in council. All right. How we know that? Because the Benedictine reform, which was done by King Edgar through his reform, as we know by St. Dunstan, all right, which was Archbishop of Canterbury, right? St. Dunstan was the Archbishop of Canterbury going back to the Canterbury, what we call the Pope of St. Augustine, going back to St. Augustine of Canterbury, going back to Pope Gregory I, with the conversion of Anglo-Saxon to what we call this new Arianism religion called Christianity. All right? Christianity. All right? Because they all go back to what we call the list of popes or the doctors of the church or church fathers. How we know that? St. Peter, all right? He was the first one back in 1 AD at the same time King Edgar the Peaceful is ruling, all right, on earth. All right, let's go down. Let's find Pope Boniface. We know what the interregnum means, right? We know what the interregnum means, that knows the demise on the transfer of the crown, because the Roman Catholic Church is assumed to be representing the crown. We know that is just not the case. Here we go. 1294, Boniface the Eighth. He the one who created the church fathers in the 13th century, backdating going back to St. Peter. All right. We just read it. He backdated all the same, going back to St. Peter, which Christ said he'll build his church. And we know St. Peter and the new ministers of Winchester shows that St. Peter is flanked by Mary in lieu of King Edgar represent the image of Christ in lieu of what we call the New Minister's Charter. And we know New Minister's Charter is a deed in lieu of what we call Christ's estate, or the crown estate, which is what we know entail for all the heirs belonging to what we call Christ. And in this case, will be King Edgar the Peaceful, because this is the image that everyone perceives him to be, that Christ image. All right? That Christ image. And this is recognized through what we call the Benedictine reform, because Benedictine reform descended down from the abstract, what we call Augustinian part and stuff. The Benedictine reform descended from the Benedictine monasteries, which is a school of black monks, which descended down from the abstract Augustinian monastery reforms. All right, going back to St. Augustine of Canterbury. All right, let's prove it. All under the list of popes. I'm not making this up. All involving the Cestui. It says the Franciscans, the Cistercians, as well as what they said, the Benedictines. All right? Okay? So here's your orders right here. These are the church fathers. Everybody pull them up. List of the popes. Religious orders, 51 popes and 6 anti-popes have been members of the religious orders, including 12 members of the third order. They are listed by the orders as follows. Starting with Order of St. Augustine. All right? And Order of St. Augustine is what? Represented by what we call St. Augustine of Hippo. Here we go. Written by St. Augustine of Hippo in the 5th century. All right? A Berber, y'all. All right? The family of Augustinians, or the monasteries of the monastery, also called the Orders of the St. Augustine, canons regular, or premonstrance, pardon myself if I pronounced that wrong, was under the popes of Eugene, Honorius, Innocent II, Lucius, Adrian, Gregory VIII, Gregory I, Boniface, Adeodatus, Leo IV and II, John the Ninth, John the Seventh, and John the the 16th, and all the other ones we see here. All right, until you get to the orders of Benedictine. All right, which is under Saint Benedict of Nursia. All right, Saint Benedict of Nursia. All right, and we know the English reform was under what we call the Benedictine monks. All right, because we know that all these were a reference to what we call the Cestui, the Augustinians, the Benedictines, the Cistercians, the Dominicans, the Franciscans, the Jesuits, the Theatines. All these are the ones who are responsible for being the trustees of the so-called estate that belonged to the king. All right? The king. The Benedictine monks. All right? Or black monks. The main religions are also sometimes called the black monks. All right? The monasteries. Well, you must understand what's going on. So that takes you back to the English Benedictine reform. Everybody pull that up. Because these are responsible for who? The Cestui. Right there. They're responsible for the Cestui. But those who are overseeing the trust must make sure that the authority in which the overseer of the trust, although the fiefman, must go back to that which was established by the Magna Carta, Quia Emptores, and the Statute of Mortmain, and qualified and managed by Henry VIII through the Statute of Uses and the Statute of Wills. All right? In the 15th century. So all these orders, monastic orders, are responsible for overseeing the trust. And with the English Benedictine reform was one of those overseers of the trust, going back to what we said, King Edward the First. All right? Which descended down from who? King Edgar the Peaceful. How we know that? English Benedictine reform. Everybody pull it up. Pull it up. English Benedictine reform. You know, reform means to make like the original. Before the original form. I'm going to show y'all in modern day case law that everything you're reading thus far is relevant. In modern day case law, the English Benedictine reform or monasteristic reform of the English church. You hear that? Let's show you the difference. This might be every bit 3 hours. Church of England. Okay? Y'all better understand. You better understand why King Edgar reformed the Benedictine reform, why that took place. You need to understand why that took place, the reformation, to make like the original. The reason why it was make like the original as a result of the conversion of the Anglo-Saxons to the Christianity that we see now. So King Edgar tried to make it like the original. That's why he was the image or the incarnation or the personification of the original. Y'all better make sure, man, look. The Church of England, contrast to the English church, is the established church, Christian church in England. It traces history to the Christian church record as existed in the Roman province of Britain by the 3rd century and to the 6th century Gregorian mission to Kent, led by Augustine of Canterbury, in which Augustine of Hippo was a member of. All right? A Berber. The English church renounced papal authority in 1534 when Henry VIII from the Lancaster branch failed to secure the papal annulment of his marriage to Catherine of Aragon. All right? The English Reformation is celebrated under Edward VI regents before the brief restoration of papal authority under Queen Mary and King Philip. The Act of Supremacy of 1558, as a result of the Supremacy Act of 1534 by Henry VIII, the Supremacy Act of 1558 by Elizabeth I, established what we call the Elizabeth Settlement for the new colonies now called the 13 colonies here in North America, which was composed of what? The classifications of Protestants, orientation, descending down from the Anglicans, with the theology of the Anglican, all right, under the Episcopal Church. The origin and the region which encompasses is what? England, Wales, Isles of Man, Channel Island, Continental Europe, as well as Morocco. Headquarters, Church House of Westminster. All right. Founder, Augustine of Canterbury, 597. That's not the Benedictine monasteries or the Reformed monastery by the English King Edgar the Peaceful, because under the King Edgar the Peaceful, to the English monastery reform, they went from being black monasteries to English monasteries under the reform. You see the difference? That's where the Æthelstan or the nobility came in. All right. So you have the English church, or the versus or contrast to the Church of England, which separated from the Roman Catholic Church in 1534. But they were part of the Roman Catholic Church as a result of Pope Gregory I's influence, St. Augustine of Canterbury in 597, to have the English heirs and successors convert to their rendition of their Christianity, which is their pagan religion, do what they call Arianism. All right? You better see what's going on. I'm showing you. Let's go back to the English Reformation. The English Benedictine Reform, monastic reform, as they said, of the English Church, and what they said, the English Church. Let's see what that brings us to. Okay. It takes you right back to the Gregorian mission. Let me just show you. The English Church, Christianity in Anglo-Saxon England. It takes you right back there to Ethelbert, Kent, and the Gregorian mission. Right there. Takes you right there, all right? So there's no need to revisit that. English Benedictine Reform or monastic reform in the late 10th century was a religious and intellectual movement in the later Anglo-Saxon period, all right? In the 7th century, 7th and 8th century, England, most monasteries were Benedictines. But in the 9th century, learnings of monasticism declined severely. Alfred the Great deplored the decline and started to reverse it. The court of Æthelstan, the first king of the whole of England, was a cosmopolitan, and future reformer such as Dunstan and Æthelwold learned from the Continental exponents of the Benedictine monasticism. So we know that Alfred the Great was the king of the Wesses. Æthelstan means noble stone. We also know that when you get into the history dealing with Albion, King Edgar the Peaceful was Augustine, what was called Emperor of Augustus, all right, of Albion. Augustus of Albion. He was the Emperor of Albion, all right? So that term Augustus is not a new term. It was used in the days of our King or our Jesus Christ, King Edgar the Peaceful. in the days of the, as they said, that the giants were living. All right. That goes to the biblical narratives. All right. The days where the giants were living in, this king was living in. All right. And that king depiction was that of his descendant Asherton. As you can see, is of a darker complexion. All right. As you can see, darker complexion. Let's read on. The court of Asherton, let me make sure y'all see that. The court of Asherton, the first king of the whole of England, was a cosmopolitan. You hear that? And future reformers such as Dunstan and Æthelwold learned from Continental exponents of the Benedictine monasticism. The English movement became dominant under King Edgar in 959 to 975, who supported the expulsion of secular clergy from monasteries and cathedral chapters and their replacement by monks. The reformers had close relations with the crown. You hear that? Furthering its interest and depending on its support. So what is the crown? The corporation soul. How could I be either how can I not be more on point than I ever been by bringing forth this information? I'm bringing the crown, making reference to the crown, going back to the Benedictine reform as established by King Edgar the Peaceful under the English Reformation of the monasteries. All right? As a result of the monasteries, due to what we call the Gregorian Reformation under those who adopted the religion of the Roman Catholic Church after started by the Church of England, going back to St. Augustine of Canterbury. All right? 597. Are we going back to Augustine of Hippo? What was it? 350. What was it? 354. Going back to Jerome or Ambrosius. All right, 339 AD. When none of them are validated, because we know that the first doctrine of the church was St. Peter in 1 AD under the Gregorian calendar, but we know in 1 AD in the Berber year is actually 951. The time of King Edgar the Peaceful through the English Reformation. All right? These are facts beyond doubt. Beyond doubt. All right, let's move further. All right, so we know that the Benedictine monastery was responsible for the Cestui. It said it right there. The Benedictine monastery was responsible for the Cestui. All right? Just like you got those for the abstract estates or the colorable estates. All right? And I'm going to show you they're colorable because they're not validated by any chain of title. All right? Chain of title, proof of the state. And the only proof of the state that going back to the chain of title, back to the original grantor, is that of entail. All right? Contrast to fee and simple. Because it said right here, you only three ways the state can be transferred: by transfer by way of what we call fee and simple, which is to anyone, fee and simple. All right, you see that? I'm not going to go through it again. Or sometimes called entail. Sometimes onto a male line, primogeniture. This is called entail. All right? Entail. All right? So if it's by male heir and it's entail contrast to fetail, which is to anyone, right? That means that if there's no one sitting in the office or the tenure as the crown, that means that it reverts back to the church in what we call under the term interregnum, because there's no demise of the power and authority under the jury regalia of the crown that belongs to the one who sits in that position as the minor. All right? There is no demise, no transfer of that sovereign authority. All right? This is what we call the world prerogatives of king and parliament. the royal prerogatives of king and parliament. Let's see, let's go here. Okay. So we know there's a difference between the Church of England and the English Church. All right. We know the Church of England resulted from the conversion of the English Church to that Roman Catholic religion called Christianity. All right. And we know that everybody's claiming to be overseers of the Cestui called the Trust, which is the religious monasteries. All right. The religious monasteries, which they gave you a couple examples of them. All right. But the only example that best qualifies the English is that which was created by the Benedictine under the English Reformation. Because under the other monasteries, they go back to what they call the church doctors or the founders of the what we call the list of under the authority of list of popes, going back to the church fathers. All right, which consists of what we said: Saint Augustine of Hippo, Jerome, Ambrosius, Boniface, Clement IV. All these so-called popes are under the authority of the Roman Catholic Church, which was abandoned by Henry VIII in lieu of the Cestui under what we call the Benedictine, not the Benedictine Reformation, the English Reformation. All right, when all the estates belonging to the crown was put into a cestui. All right, the cestui, and the English Church, which was represented by Henry VIII, goes back to the English Benedictine monastery as received that responsible as power of attorney. All right, as power of attorney. Let's go back to cestui. Like that. Where's it go? Right here. Religious orders such as the Franciscans, Cistercians, Benedictines, and other mendicant orders took vows of poverty, yet retained the use of the donated property. All right? They're the overseers of the property. All right? All the other orders, Franciscans, Cistercians, Augustinians, is referring to the abstract stories. Contrast to the true story, which was brought to fruition through the English Reformation. All right, the English Reformation of not the English Reformation, the English what is called the English Benedictine Reform. All right, the Reformation of the monks. What are the Franciscans and the Cistercians? Let's look at these right quick. We know Franciscan was created by Pope Francis of Assisi, and that goes back to what we said the Holy Sepulchre. All right, what is the Cistercians? Who are these? Or what are these? Or what is this? I should say. All right, Catholic religious order of monks and nuns that branch off from the Benedictines to follow the rules of Saint Benedict of Nursia, as well as contributions of highly influential Bernard of Clairvaux, known as Latin rule. All right, so these are your church fathers. All of them, this broke off from the Benedictine order. All right, as you just seen. Was the Benedictines? Let's look them up real quick. Our main contemplative monastic religious order of the Catholic Church for men and women who follow the rules of Saint Benedict. The male religious are also called black monks in reference to the color of their religious habits, pace Olivetans, which wear white. Okay, going back to Saint Benedict of Nursia, on which Saint Dunstan was associated with. All right, and we know that this was reformed through the English Benedictine reform, going back to King Edgar the Peaceful, which is associated with the crown. Okay, the crown. All right, which consists of a natural person. All right, not a spook. All right, which are the other ones speak about. All right, it speaks of a natural person. Let's just qualify it. Crown. Right here, y'all. The concept of a crown as a corporation soul developed first in the Kingdom of England. So a crown is a corporation soul. What's the corporation soul? Everybody use this term loosely. A corporation soul is a legal entity consisting of a single incorporated office, not unincorporated. It didn't say unincorporated. It said incorporated office occupied by a single sole natural person. It didn't say unnatural person, because the church is unnatural. All the property belongs to the unnatural church because it's not a natural person. The church itself represents the English throne, which represents the crown, because the church is the place where the English throne sits, which represents the crown, personified by the natural person, which sits on the throne, i.e., the crown. All right. This structure allows corporations to pass without interruptions, i.e., demise, from one office holder to the next, giving position legal continuity with subsequent office holders having identical powers and possessions to their predecessors. That means perpetual. All right. Contrast to what we call corporations, which is aggregate. This is very important right here. Most corporation souls are church related. Although some political officers of the United Kingdom, many of the secretaries of state, Canada, and United States are corporation souls. Why? Because secretaries of state are ministers of foreign affairs. All right. The origins of Secretary of State of the United States goes back to Secretary of State of the United Kingdom, which originated where the Secretary of State of the colonies originated from. Yes, the Secretary of State of the United States originated from Secretary of State of the colonies, which is under authority of Secretary of State of the United Kingdom, which originated from the Secretary of State of what we call England. Yes, sir. These are facts. All right. You have to know this. All right. You have to know this. And these are assumed to be what we call corporation sole de facto, not de jure. They are de facto. All right. Let's move forward. Okay. All right. Now I can bring it home. So a lot of y'all say, well, why you keep going over this King Clifford Jefferson? All right. Why you keep going over this history when it has no relativity to this country or these laws or these people? All right. When it's totally the opposite. It has it has an adhesive relationship. You know what I'm saying? It has a very adhesive relationship that ties into the integral aspect of the origin of where the adhesives of this adhesive originated from, going back to the contractual agreements of the parties. All right, it's very, 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 very important to understand this because it all deals with this trust. It's called the Cestui, and the Cestui deals with what we call the land. All right, the land. You have no estate if it's not, or if you don't have the right to the possession of the so-called land. All right, you don't have a right to it. Let's prove that. Let's go to case law. We know that the crown, a corporation sole, they said the archbishops, right? They said the archbishops are presumed to be corporation souls as well. Where was it at? Why is that the case? Why is that the case? Why is this so important? Because we already know that the crown was associated with the English Benedictine Reformation, right? We know that the crown was associated with the English Benedictine Reformation and not the Church of England. All right, once again, the crown was associated with the English Benedictine Reformation, which was associated with the English Church, and not the Church of England, which was associated with the archbishops of Canterbury, going back to Augustine of Canterbury through the Gregorian mission. All right? To the Gregorian mission. Where is it at? Ecclesiastical origin of corporation soul. Most corporation souls are church related. For example, the Archbishop of Canterbury, as I said earlier, and Archbishop of Canterbury goes back to what we call St. Augustine of Canterbury, all right, associated with the Church of England, going back to the Gregorian mission that was orchestrated by, which was given the authority by Pope Gregory the First. All right, Pope Gregory the First, the Pope of the Roman Catholic Church, ordered the conversion of all Anglo-Saxon burghers to the religion of Christianity. All right, that was found, which involved the Cestui, which was under the control of those who represented the Roman Catholic Church under the Archbishops of Canterbury. All right, but they were not corporation souls because they were not representing the natural person. All right, i.e., the crown. They have nothing to do with the crown. All right, nothing at all. Why? Because we go back to the English Reformation, just to qualify it. Where is it at? Right here. Okay. English Reformation. Very important. We look and read over words. The English Benedictine reform or monastic reform of the English Church. It didn't say the Church of England. It said the English Church. We know that the list of popes involved the Augustinian monasteries, the Cistercian monasteries, the Benedictine monasteries, and other monasteries that exist to this present day. All right. Well, we know that the English Benedictine monastery reformation happened in the time of King Edgar the Peaceful because of the uh, 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 reformation of the English Church through the Gregorian mission as established by the Roman Catholic Church under Pope Gregory I through Augustine of Canterbury. All right, which was one of the church founders or the church fathers as initiated by Pope Benedictine VIII. All right, which backdated it all. I'm going back to St. Peter the First. All right, which is depicted here in the English Benedictine Reform Charter with King Edgar presented to the Christ image right here. All right, there's the charter. There's St. Peter, there's Mary. All right, this is the English Benedictine Reform, and we know that under the monastic orders as established by the popes, It said that the first one was the Augustinians, and the second one was what? The Benedictines. All right. Then the next one they had was the Franciscans, Dominicans, Franciscans, all these going back to times in history that don't reflect this present in regards to the authority governing the kings of England, as it did under the English Reformation of the Benedictine monasteries, which was under the authority of a king of England. All right? Yes, the king of England. All right? So let's bring this on home. Case law. This is all dealing with debt. We know debt is revenue for the king. All right? Debt is revenue to the king because it deals with international trade. International trade or international foreign affairs or foreign trade or foreign affairs, which comes up under what we call uh, uh, matters that involve the exchequer of the king's finances. That's what it involves. So when you're dealing with the a debt here in one of these so-called territories called New Mexico, in regards to the matter heard by the District Court of New Mexico, it was this in-way Roman Catholic Church of the Archdiocese of Santa Fe, and regarding the debt that they claimed that the Roman Catholic Church owed, but the church was exempt as a result of the assumed status as a corporation sole. All right, under the assumed status as a corporation sole. All right, but we already know that a corporation sole is a natural person. All right, the corporation sole is a natural person. When you hear the word archdiocese and corporations, so can be archdiocese. We know that goes back to the Roman Catholic Church, going back to the Reformation of the English Church under St. Augustine of Canterbury under Pope Gregory I, where all the English heirs and successors of the English Church converted to Christianity. All right, which is the predominant religion we have here in its present day. All right, which makes us all debtors to the church. Why? Because we now become what we call legal persons or corporations. All right, or what we call non-natural persons, legal fictions. All right. It says here, the facts of the case. For the limited purpose of ruling on a motion, the court finds that the following facts are not in dispute. In 1875, the Roman Catholic Church created the Archdiocese of Santa Fe. In 1951, the Archdiocese incorporated as a corporation sole. All right? Once again, incorporated as the corporation sole. But the Roman Catholic churches of the Archdiocese, going back to Augustine of Canterbury, are not incorporated. They're unincorporated. All right? They're unincorporated. Why? Because they're aggregate. We know there's a separation of church and state. So they can't be incorporated with the state because then they would lose their sovereignty. All right? There's laws against religious societies incorporating as a corporation sole. All right? If it's not done properly. The only proper way to create a corporation sole is by way of that office being entailed and personified by the crown, which is originated from the original content of where the crown was established for, as a public trust. Let's qualify. All right. It says here, page 2 of 8. Debtor is a corporation sole. Debtor is a New Mexico corporation sole organized in 1951. They're talking about the Archdiocese. New Mexico's current statute do not refer to corporation sole. In 1951, however, the legislature, i.e., not the executive branch, not the judiciary branch. The judiciary branch is upholding statutory amendments to allow the incorporation of corporation sole, even though it's de facto. All right? Because there must be an office. All right? There must be an office. All right? It says here, the court set a claim bar date of June 17, 2019. It says, incorporate the statute as follows. Any person in whom shall be vested the legal title to the property of any church or religious society in conformity with its constitution, canons, rights, or regulations, and of any scientific research institution maintained solely for the pure research and without hope of pecuniary gain or profit, may make and subscribe written articles of incorporation and acknowledge the same and file a duplicate of such articles for record in the office of the county clerk of each county in which any real property of such corporation is situated, together with an impression of the seal, which it shall adopt. Such corporations souls shall be perpetual in existence and shall vest in the successors and office to the person so complying with the provisions hereof, entitled to all property vested in such corporation soul, hereunder shall also vest in such successors in that office. All right? Everybody take that and read that again. Because we know we just read corporation soul is represented by the crown as a natural person. All right? A natural person. We also know that a corporation's console can be also invested in the archdiocese. All right, the archdiocese goes back to the what we call the diocese or the bishop of the Roman Catholic Church, going back to the conversion of the English church to the Christian church by the conversion of the English subjects to Christianity, which is called Arianism, through the conversion of the Gregorian mission that was established by Pope Gregory I and St. Augustine of Canterbury, which was one of the monastic order who was the overseers as the power of attorney of the what we call the Cestui. All right, the land tenure, i.e., the public trust. All right, when it was divvied out under what we call fee and simple estates. All right, under what we call a general warranty and covenant. All right, a general warranty and covenant, which is what we said has exclusionary rights. All right, also encompasses as well, which we discussed in case law, which will validate everything I'm saying here in regards to this case we're reading here. All right, so we know that the Roman Catholic Church or the archdiocese and the bishops who represent the archdiocese goes all the way back to that concept of time immemorial in the abstract story versus the concrete story going back to time immemorial, ending with Richard the First. All right, son of Henry II, son of Godfrey V, Count of Anjou. All right, all dealing with the so-called fiefman, which is Cestui called a trust, which was protected by the statutes of Queen Emptores and the Statute of Mortmain. All right, by Edward the First of the Plantagenet crown. We're going to prove all that in case law. All right. So we see that once again, the Roman Catholic Church, the Archdiocese, has its origin in time immemorial, going back to the Gregorian Reformation, going back to Pope Gregory I and St. Augustine of Canterbury, all right, which all your church doctors descended down from by way of the institution of the church doctors that was established by Pope Boniface VIII, all right, who also had participated in the Scottish independence in 1295 when they were subject to the Plantagenet King Edward I, all right, through the Scottish independence. All right, this is all proof. Everybody take a second and warm my coffee up. All right, so this is one case. Let's go to another case. Chisholm versus Georgia. All right. Chisholm versus Georgia is a United States Supreme Court case that deals with a citizen right to redress for remedy to the government, all right, or to the crown. In this case, in our case, will be the crown, and the states or the United States will be the what we call the state's government, represented by what we call the Attorney General. All right. I'm sorry I make these videos long, but they have to be. I highlighted what I wanted to focus on. This case deals with bringing a claim against the state for what we call trespass. This is called an action of assumpsit. All right, trespass. The action is an act of assumpsit. The particular questions then before the court is will an action of assumpsit lie against a state? This particular question abstract from the general one, whether a state can in any instance be sued. I took the liberty to propose to the consideration of the Attorney General in the last term. All right. The question as before observed is will an action of trespass lie against a state? If it will, it must be in virtue of the Constitution of the United States and some law of Congress comfortable thereto. The part of the Constitution concerning the judicial powers is as follows. Article 3, Section 2, the judicial powers shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made or which shall be made under their authority. Article 6, as under the Articles of Confederation. 2, to all cases affecting ambassadors or other public ministers and consuls. Article 6 and Articles of Confederation. Article 3, to all cases of admiralty and maritime jurisdiction. Once again, Article 6 of the Constitution and the Articles of the Confederation. All right. The United States shall be a party. 5, to controversy between two or more states, between the states and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between states or of citizens thereof and foreign states, citizens or subjects. All right, so all this deals with claiming land under what we call a trust. It all involves a trust. Who has the right to this trust? All right, and if it's a trust and in the state and somebody's trespassed, you have the right to remedy by petition of right, which this case speaks to. All right, a petition of right. The Constitution therefore provides for the jurisdiction wherein a state is a party in the following instances. First, controversies between two or more states. Second, controversy between a state and a citizen of another state. Third, controversy between a state and a foreign state, citizens or subjects. And also provides that in all cases in which a state shall be a party, the Supreme Court shall have original jurisdiction. The words of the General Judicial Act convey the authority of the Supreme Court under the Constitution so far as they concern these questions are as follows. Section 13, the Supreme Court shall have exclusive jurisdiction of all controversies. So if it's a state federal matter and we lose the Supreme Court have, it must involve a controversy in lieu of that state or the United States or the federal government sovereignty. All right. If it's a state, it's a sovereignty that they maintain after that, which was surrendered to what we call the federal government, which was preceded by the Articles of Confederation. All right, and we know that the powers that the states have, that they did surrender to the Articles of Confederation, shall remain the same. All right, shall remain the same, and that power is king and parliament. All right, because the power of king and parliament cannot be surrendered to what we call the executive branch. All right, we're gonna prove that. The Supreme Court shall have exclusive jurisdiction of all controversies of civil nature where a state is a party, except between a state and a citizen, and except also between a state and a citizen of other states or aliens. And in which later case, it shall have original, but not exclusive jurisdiction. It shall have exclusively all jurisdictions of suits or proceedings against ambassadors and or other public ministers or their domestic or domestic servants, as a court of law can have or exercise consistently with the law of nations, and original but not exclusive jurisdiction of all suits brought by ambassadors or other public ministers, or in which a consul or vice consul shall be a party. Let's move forward. Hold on for a second. So forward. So Article 3, Section 2 of the United States Constitution, yes, you can seek redress remedy by way of what we call a petitioner right. All right. A petitioner right has been one of the formidables and allowable judicial reliefs that are allowed from time immemorial. All right. From time immemorial, this is recognized in the United States Supreme Court. Let's validate this. Let's see here. Let's start right here. Now like this. Okay, right here. I was just thinking this. I was going to say this. I wanted to find the articles in regards to the sovereignty that the so-called states say they have, or the federal government say they have. And the only sovereignty that you have is that which was surrendered to you by the power that granted you, i.e. the grantor. So we know that the federal government sovereignty is only that sovereignty that was surrendered by the state, and that was not surrendered to the federal government by the states maintained, which was no sovereignty at all. Okay, they didn't have any sovereignty based off their status. All right, as under the Articles of Confederation. It says here, the statutes of England that are enforced in America differ perhaps in all states, and therefore it is probable the common law in each, in some respects, different. But it's certain that in regards to any common law principle which can influence the question before us, no alteration has been made by any statute which could occasion the least material difference or have any partial effect, as stated in Smith versus Alabama. All right, there's only one common law, and that's the common law of England that was adopted by all the several states, which must be looked at in light of its general history. All right, and of its general history. No other part of the common law of England, it appears to me, can have any reference to this subject, but that part of which prescribed remedy against the crime. All right. Every state in the Union, in every instance where its sovereignty has not been delegated to the United States, I consider to be completely sovereign as the United States are in respect to the power surrendered. So as I said, the power of the states is sovereign, subject to that power surrendered to the United States, which they assume to be sovereign. All right. As I read and reiterate again, every state in the Union, in every instance where its sovereignty had not been delegated to the United States, I consider to be as completely sovereign as the United States are in respect to the power surrendered. The United States are sovereign as to all the powers of government actually surrendered. All right. Each state in the Union is sovereign as to all the powers reserved. It must necessarily be so because the United States have no claim to any authority but such as the states have surrendered to them. Once again, I repeat, the United States are sovereign as to all the powers of government actually surrendered. Each state in the Union is sovereign as to all powers reserved. It must necessarily be so because the United States have no claim to any authority but such as the states have surrendered to them. So only power that the United States have is that power that the states surrendered. And we know that power that the states surrendered to the United States, i.e. that 13 colonies, was the power belonging to rightfully king and parliament. All right? We must understand that. All right. It must necessarily be so because the United States have no claim to any authority but such as the states have surrendered to them. Of course, that part not surrendered must remain as it did before. The power of the general government, either of a legislative or executive nature, or which partially concerns treaties with foreign powers, do for the most part, if not wholly, affect individuals, not states. All right. So as a result of the treaties that are made by the United States, affects individuals, not states. All right. And we know that the states who make up the United States are actually states themselves that are composed of the sovereign people. And when the United States go make treaties with other nations under foreign compacts, foreign agreements, foreign contracts, it affects us here at home. Okay? It affects us here at home. All right? This is the process that's used here in the United States, at contrast to the process that's used over in England, which the United States has took the authority because the practice here in the United States was that of the practice of England. As it is stated, there is no other part of the common law of England, it appears to me, can have any reference to this subject but that part of which prescribes remedy against the crown. All right? And we know the crown was here in New Jersey in 1776. Let's move forward with this case law. Oh, this case is good. All right, I'm back. All right, so all those who watch this video, please forward this video to all the podcasters out there, Silent TV, Salvatore Seti, all the other video platforms out there. You know, I love to be invited to the platform, or I can invite you to mine, so that we can bring to once and for all a resolution and an end to the misunderstanding of who we are as a people. All right, by the proof that I'm bringing to you in this present day. All right, you know what I'm saying? This is concrete proof. All right, from the record. It says here also, if therefore no remedy be provided, as plainly is the case, and consequently we have no other rule to govern us but the principles of the pre-existent laws, which must remain in force till superseded by others, then it is incumbent upon us to inquire whether previous to the adoption of the Constitution, which period or the period of passing the law in respect to the object of this inquiry, it is perfectly equal. An action of the nature like this before the court could have been maintained against one of the states in the Union upon the principles of the common law, which I have shown to be alone applicable. If it could, I think it is now maintainable here. If it could not, I think as the laws stand at present, it is not maintainable, whatever opinion may be entertained upon the construction of the Constitution as to the power of Congress to authorize such a one. Now I presume it will not be denied that in every state in the Union, previous to the adoption of the Constitution, the only common law principle in regards to suits that were in any manner admissible in respect to claims against the state were those which in England apply to claims against the crown. There being certainly no other principles of the common law which previous to the adoption of this Constitution could in any manner or upon any color apply to the case of claim against a state in its own courts, where it was solely and completely sovereign in respect to such cases at least. Whether that remedy was strictly applicable or not, still I apprehend that there was no other. The only remedy in case like that before the court by which by any possibility a suit can be maintained against the Crown of England or could be at any period from which the common law as enforced in America, y'all, could be derived, I believe is that which is called the petition of right. That until the time of Edward I, the king might have been sued in all actions as a common person, and some authorities are cited for that position, though it is even there stated as a doubt. But the same authority adds, but now none can have an action against the king, but one should be put to sue to him by petition. All right, let's move a little further. This case is really good. By all these authorities and by many others which I could cite, both ancient and modern, it is plain that if the subject was to recover a rent or annuity or other charge from the crown, whether it was rent or annuity originally granted by the king or issuing out of lands which by subsequent title came to be in the king's hand, in all cases the remedy to come at it was by petition to the person of the king. You hear that? Of the king. And no other method could be shown to have been practiced at common law. Indeed, I take it to be generally true that in all cases where the subject and the nature of a plaintiff to recover anything from the king, his only remedy at common law is to sue by petition to the person of the king. The person of the king. I say, where the subject comes as a plaintiff. You hear that? I say, where the subject comes as a plaintiff. For as I said before, when upon a title found for the king by office, the subject comes in to traverse the king's title or to show his own right, he comes in the nature of the defendant and is admitted to interplead in the case with the king in defense of his title, which otherwise will be defeated by finding the office. So if there's no one sitting in the office of the king, no one can petition the king as a matter of right. You hear that? Y'all must understand. Let's go further. Listen to this. This is what we need to be sitting around talking about, all right? What the judiciary sit around and talk about in their chambers, all right? All right? And in their private discussions, not in public, all right? They ain't in the courtroom speaking this to the parties. It's in their judicial review based off their understanding of what we call case law, which fits the agendas that they represented, reflecting that which exists before that as the standard. All right? As the old standards, the old authorities, the old depositories of law, which were deposited by the old depositors of the law, i.e., the judges. All right? It said in the old authorities, there does not appear any discussion between debt that might be contracted personally by the king for his own private use, and such as he contracted in his political capacity for the service of the kingdom. As he had, however, then fixed and independent revenues, all right? We know revenues deals with tariffs, upon which depends the ordinary support of government as well as the as well as the expenditures for his own private occasion. Probably no material distinction at that time existed or could easily be made. A very important distinction may, however, perhaps now subsist between the two cases, for the reason imitated by Lord Mansfield, since the whole support of government depends now on parliamentary provisions, and except as in the case the civilists, those for the most part annual. Thus, it appears that in England, even in the case of a private debt contracted by the king, in his own person, there is no remedy but by petition, which must receive his express sanction. Otherwise, there can be no proceeding upon it. If the debt contracted be avowedly for the public use of government, it is at least doubtful whether that remedy will lie. And if it will, it remains afterward in the power of Parliament to provide for it, or not among the current supplies of the year. Now, let us consider the case of a debt due from a state. None can I apprehend by directly claim, but in the following instances. First, in the case of contract with the legislature itself. Two, in the case of contract with the executive or any other person in consequence of an express authority from the legislature, which means that if the executive branch goes into a contract, the authority in the legislature must simplify that. Or third, in cases of a contract with the executive without any special authority. In the first and second cases, the contract is evidently made on the public face alone. Every man must know that no suit can lie against who? The legislative body. His only dependence, therefore, can be that the legislator, on principles of public duty, will make a provision for the execution of their own contracts. And if that fails, whatever reproach the legislature may incur, the case is certainly without remedy in any court of that state. So it means that there can be no separation of the fusion of power, which means the executive and legislative power, because we know in the king and parliament it represented a fusion of government, the king and parliament, versus that of a fusion of government, a non-fusion of government of the executive and legislative power. If the executive power is the exercising of legislative authority, that's a violation of the legislative branch, because any power in a branch of one branch of government is a violation of law. That's a violation of what they said, the public trust. All right? That's what the separation of powers was actually established for. All right? So it says here, it never was pretended, even in the case of the Crown of England, that if any contract was made with Parliament or with the Crown by virtue of any authority from Parliament, that a petition to the Crown would in such case lie. In the third case, a contract with the governor of a state without any special authority. Once again, I repeat. It never was pretended, even in the case of the Crown of England, that if any contract was made with Parliament or with the Crown by virtue of an authority from Parliament, that a petition to the Crown would in such case lie. In the third case, a contract with the governor of a state without any special authority. This case is entirely different from such a contract made with the Crown of England. The Crown there has very high prerogatives in many instances, and a kind of trustee for the public interest. In all cases represent the sovereignty of the kingdom, and is the only authority which can sue or be sued in any manner on behalf of the kingdom in any court of justice. Once again, the Crown there has very high prerogatives in many instances, and a kind of trustee for the public interest, and in all cases represent the sovereignty of the kingdom, and is the only authority which can sue or be sued in any manner on behalf of the kingdom in any court of justice, i.e. king and parliament. All right? King and parliament. Because we know that king and parliament represents the fusion of government, and the laws by the king and parliament, i.e. the fusion of government, is represented by the king or upheld by the king and his judiciary, known as the King's Bench. All right? The King's Bench. The Crown there has very high prerogatives, i.e. royal prerogatives, as established in the United States Fidelity Company versus Carta. All right? We read through that case. United States Fidelity versus United States Fidelity Company versus Carta, a 1933 case. This case entirely different from such contracts made with the Crown of England. The Crown, therefore, has a high prerogative in many instances and is a kind of trustee for the public interest. In all cases, represents the sovereignty of the kingdom, and is the only authority which can sue or be sued in any manner on behalf of the kingdom in any court of justice. A governor of a state is a mere executive officer. His general authority very narrowly limited by the Constitution of the state, with no undefined or undisputable prerogatives, without power to affect 1 shilling of the public money, but as he is authorized under the Constitution or by a particular law, having no color to represent the sovereignty of the state, so as to bind it in any manner to its prejudice, unless special authorized thereto. Amendment, statutes, statutes and laws, codes, etc., executive orders. This would give the executive officers, i.e., the executive branch, authority to overstep their boundaries as designed by the legislative branch. All right. And therefore, all who contract with him do it at their own peril and are bound to see or to take the consequence of their own indiscretion, that he has strict authority for any contract he makes. Once again, I repeat, I'm going to start back from here. The Crown, under the King and Parliament, has very high prerogatives. In many instances, is a kind of trustee for the public interest. In all cases, represent the sovereignty of the kingdom, and is the only authority which can sue or be sued in any manner on behalf of the kingdom in any court of justice. A governor of a state is a mere executive officer. And this ain't nothing about no president. All right? Nothing about a president. All right? And this is the United States court case. All right? This is the United States court case. All right? And it said a governor of a state is a mere executive officer. His general authority is very narrowly limited by the Constitution of the state, just as the president is limited by the state's Constitution, United States Constitution, with no undefined or disputable prerogative, without power to affect 1 shilling of the public money, but as he is authorized under the Constitution or by a particular law, having no color to represent the sovereignty of the state, so as to bind it in any manner to its prejudice, unless special authorized thereto. And therefore, all who contract with him do it at their own peril and are bound to see or to take the consequence of their own indiscretion, that he has strict authority for any contract he makes. Of course, such contracts, when so authorized, will come within the description I mentioned of cases where public faith alone is the ground of relief and the legislative body the only one that can afford a remedy, which from the very nature of it must be the effect of its discretion and not of any compulsory process. If, however, any such case were similar to those which would entitle a party to relief by petition to the king in England, that petition being only presentable to him as he is the sovereign of the kingdom, so far as analogy is to take place, such petition in a state can only be presented to the sovereign power, which surely the governor is not. You hear that? The governor is not the sovereign power, y'all. The only constituted authority to which such a application could with any propriety be made, most undoubtedly be the legislator, who express consent upon the principles of analogy will be necessary to any further proceeding, so that this brings us, though by a different route, to the same goal, the discretion of good faith of the legislative body. There is no other part of the common law besides that which I have considered, which can by any person be pretended in any manner to apply to this case, but that which concerns corporations. Did you hear that? The applicability of this, the Attorney General, with great candor, has expressed way, but as may be urged on the other occasions, as I wish to give the full satisfaction, I will say a few words to that doctrine. Suppose, therefore, I should be objected that the reasoning I have now used is not conclusive, because inasmuch as a state is made subject to the judicial power of conquest, its sovereignty must not stand in the way of the proper exercise of that power, and therefore in all such cases, though in no other, a state can only be considered as a subordinate corporation merely. 1. First, I answer first that the construction can only be allowed at the utmost upon the supposition that the judicial authority of the United States as it respects states cannot be effectuated without proceedings against them in that light, a position I by no means admit. Second, that according to the principles I have supported in this argument, admitting that states ought to be so considered for that purpose, an act of the legislator is necessary to give effect to such a construction, unless old doctrine concerning corporations will naturally apply to this particular case. Third, that it is evident that an act of Congress has not made any special provisions in this case, grounded on any such constructions, so it is to my mind perfectly clear that we have no authority upon any supposed analogy between the two cases to apply the common doctrine concerning corporations to the imposed case now before this court. I take it for granted that when any part of any ancient law is to be applied to a new case, the circumstances of the new case must agree in all essential points with the circumstances of the old cases which the ancient law was formerly appropriated. Now, there are, in my opinion, the most essential differences between the old cases of corporations to which the law intimidated has reference, and the great extraordinary case of states separately possessing, as to everything simply relating to themselves, the fullest power of sovereignty, and yet in some other defined particulars, subject to the superior power composed out of themselves for a common welfare of the whole. The only law concerning corporations to which I can see the least references to this had to be in the common law of England on that subject. I need not repeat the observations I have made in respect to the operations of law in this country. The word corporation, in its largest sense, has a more extensive meaning than people generally are aware of. Any public politic, sole or aggregate, whether its power to be restricted or transcendent, is in a sense a corporation. The king, accordingly, in England is called a corporation. By a very respectable author is the parliament itself. You hear that? The king is parliament itself. In this extensive sense, not only each state singly, but even the United States may without impropriety be termed corporations. I have therefore, in contradistinction, this large and indefinite term used the term subordinate corporations, meaning to refer to such only as alone capable of the slightest application for the purpose of the objection, which creation and whose powers are limited by law, i.e., their constitution. The differences between such corporations in the several states in the Union as relative to the general government are very obvious in the following particulars. First, a corporation is a mere creature of a king or a parliament, and very rarely of the latter, most usually of the former only. It owes its existence, its name, and its laws, except such laws as are necessarily incident to all corporations merely as such, to the authority which created, i.e. statute. A state does not owe its origin to the government of the United States in the highest or in any of its branches. It was in existence before it. It derives its authority from the same pure sacred source as itself, the voluntarily and deliberate choice of the people. Second, corporations can do no act but what is subject to the revision of either of a court of justice or some other authority within that government. A state is altogether exempt from the jurisdiction of the courts of the United States or from any other exterior authority unless the special instances where the general government has power derived from the Constitution itself. Third, a corporation is altogether dependent on the government to which it owes its existence. Its charter may be forfeited by abuse. Its authority may be annihilated without abuse by any act of that legislative body. A state, though subject in certain specified particulars to the authority of the government of the United States, is in every other respect totally independent upon it. The people of the state created, the people of the state can only change its constitution. Upon this power, there is no other limitation but that imposed by the Constitution of the United States, that it must be a republic form. All right, let me see if this is it. That takes me here. Reed. Reed versus Elberry. Supreme Court of Florida. This law deals with clearing a cloudy title based off the parties that are involved. Territory that was subject to the crown, or i.e. the Spanish crown, being that Florida, West Florida, and East Florida was subject to British Florida. And British Florida goes back to the Treaty of Paris of 1763. All right? When all the territory that was under the territory of France was ceded, and Spain was ceded to Great Britain by the Treaty of Paris. All right? So this case involves acquiring the title of territorial parcels of land that was issued to somebody by way of a last will and testament. And when the claim was filed with the court, it violated the prescription in lieu of the statute of limitations. And the statute of limitations, in lieu of the general warranty, in lieu of the fee and simple deed, was conveyed to the Roman Catholic Church, as we've seen in the same church in Mexico, under the Archdiocese of the Roman Catholic Church of what we call St. Augustine of Canterbury. All right, same issue we have here. All right, the same issue. Let me make sure you see this. Supreme Court Florida Division Reed et al. Versus Barry, 1927. The appellant Patrick Barry, Bishop of St. Augustine of the city of St. Augustine, St. Florida, filed a bill in court below to remove a cloudy and claim of the defendant. That means there was a cloudy title on the so-called land as a result of for one of an owner. All right, for one of an owner. So if there's for one of an owner, that means that it falls under police power, and the police powers allows what we call eminent domain under what we call easements. All right. Easements are divided by way of what we call prescription, right? Which is the case at hand. So it says that the appellant Patrick Barry, our Bishop of St. Augustine, we filed a bill to cloudy a title on land that was converted to the church by what we call Robert Reed and his ancestors. All right. The pertinent portions of the bill are as follows: that the Roman Catholic Church is and has been from time immemorial an unincorporated religious organization, and that from the purpose of carrying on its religious work, that the country has been divided into dioceses, and the bishops appointed by each diocese from time to time was charged over the territory contained within the respective diocese over which he was charged of the churches belonging to the state religious organization. The state of Florida, except a small piece of territory in West Florida, resides within the limits of the Diocese of Mobile, composed of the diocese which is under the management and control of the Bishop of St. Augustine and has been since territorial days. All right, so this goes back to the time immemorial. Time immemorial in the abstract story goes back to the conversion of the Anglo-Saxon state by St. Augustine, who was in charge of the Roman Catholic Church in lieu of the property that was put in the trust by Henry VIII, who broke away from the Roman Catholic Church, going back to the Church of England, which goes back to St. Augustinian monasteries that were established by St. Augustine of Canterbury. All right? And we see the territories that were territories belonging to the trustees going back to that time was now overseen by the trustees of the Church of St. Augustine in Florida, which was a territory under the Spanish crown. All right? That was acceded to Great Britain as the Treaty of Paris of 1783. All right. And now a cloud of title was being put on it by the Roman Catholic Church, which is, as they say it right here, was an unincorporated. All right. And we know if it's unincorporated, then you can't be the owner of Intel Estate, because Intel Estate is under the crown, which is incorporated by the crown, which is incorporated, not unincorporated. All right. We know the crown is incorporated by a natural person, contrast to unincorporated by a non-natural person. All right. And if it's unincorporated by a non-natural person, that means that it falls under what they call the Statute of Mortmain, a dead pledge. It remains a part of the church. Okay. You can time pull this case up. I'm just going to go into the important aspects of the case and what it involved. The bill was for a deed that the Roman Catholic Church had by way of the statute of limitations in lieu of prescription on behalf of the Robert R. Reed on the so-called Actual Testament that they claimed was left for their heirs, absent of the term or the word or the phrase heirs and successors. All right, absent of the word heirs and successors, it automatically was not an intel estate, but a estate in fee and simple, which we're going to see here. It said here that the deed further contained a full covenant of season, which means possession, and a title in fee and simple. All right, so that means that the Roman Catholic Church, under the archdiocese or the archbishop of St. Augustine, going back to the monasteries of going back to the Cestui Trust. All right, they said the only type of estate they had was that which resulted of it being sold. All right, not being kept in the family and doing what we call an intel estate, therefore a male heir by way of what we call primogeniture. All right. It said here the deed further contained full covenants of season and a title fee and simple of a absolute and indefeasible estate of inheritance and a right to convey. Also a covenant for acquired enjoyment and possession of the property without suit or molestation of the grantor or assignees, also against encumbrances in full covenant or warranty. All right? Full covenant warranty for the life of the use of it while it's in their possession. All right, let's move forward. St. Augustine used the same church for rectory and school purposes under color of title. It is contended on behalf of the appellee that the fact alleged in the bill shows that the appellants are barred by the statute of limitations and also show good title and the appellees by adverse possession. So the appellee is saying that the bill presented by the appellant is notwithstanding as a result of the statute of limitations as a result of when the bill was brought forth before the court, which was in the 1920s, when the so-called party, the grantor died, was in 1900s. It was 20 years later, and the prescription was for 20 years. All right, so this is why the appellant said that the appellant was barred in lieu of the statute of limitations, which was shown for good cause for the adverse possession, i.e., the easement or the prescription. All right, let's move further. Where it says here, it says, where any real estate shall hereafter be conveyed or granted without their being used in the conveyance or grant in any word or limitation, such as heirs or successors or similar word, such conveyance or shall be construed to pass free and simple or other whole estate or interest which the grantor had power to dispose of in any real estate conveyed or granted, unless a contrary intention shall appear in the conveyance or the grant, i.e., the deed. All right. There must be a stipulation in the deed pursuant to the conveyance on how the conveyance or transfer of the estate will be transferred. All right. Whether it's going to be in fee and simple or fee and tell. All right. Fee and simple or fee and tell. As in they said it says 2K. Let's go back to says 2K. All right, right here. We're talking abstract before. Now I'm bringing the concrete. So I'm going to show you in case law that makes reference to the very same thing that we are talking about in regards to the illustrious history and sermon our trust that was left in a public trust for a natural person, one single natural person, not a bunch of spoofs that came to come back to redeem you. All right. It says here, the origin of the so-called trust, all right, and the purpose of the trust, cestui or fiefment, was that if it wasn't a natural person, then it would be left for the church, which is a non-natural person, all right? And if it was left for a natural person, then it will automatically fall under this guise of fee and tell, all right? Fee and tell is denotes what we call crown land, because crown land is intel land, personified by the crown, i.e. the corporation sold. If it's not done that way, then that means that it's sold by sole feudation by what we call fee and simple. All right? Where is it? Transfer to anyone. Fee and simple. It's right there. Transfer to anyone. All right? That's through common recovery. All right? We know we're dealing with the property of the English church. When you go back to the English Benedictine Reformation, as by King our Jesus Christ, which I'm the reincarnation of, how I know where the trust was at. How did I know this? All right, because that was the basis of the trust was left for to be looked over by the what they call power of attorneys. All right, the powers of attorney. It says it right here. The English movement became dominant under King Edgar, 959, when he came to be king. All right, he died in 975. Who supported the expulsion of all secular clergy from the monasteries and cathedral chapters and their replacement by monks. The reformer had close relations with the crown. You hear that? Close relations with the crown, furthering its interest and depending on its support. All right? We know the crown as a corporation soul. All right? Which consists of a natural person. All right? Let's go back to the case. Okay, let's move further. Okay. All right. Apelles further contends that the deed here in question was a trust deed creating a trust in Bishop Moore of the Saint of the Bishop of the Roman Catholic Church, Saint Augustine, because we know that that was created by Saint Augustine because Saint Augustine, and which was the case, was in Florida, and we know Saint Augustine is the capital in Florida, named after Saint Augustine of Hippo, the Algerian Berber or the Libyan Berber. All right, one of the doctors of the church, which was not recognized till Pope Boniface VIII put him on the scene by creating the doctrines of the church doctors. All right, it says here. Apelles further contends that the deed here in question was a trust deed created in a trust by Bishop Moore, which passed to his successors in a fee simple estate, rendering the absence of the word heir immaterial. The rule being that a trustee takes a legal estate commensurates with the duties of a trust and the equitable estate vested in a cestui. All right? A cestui trust, without regard to the words and the limitation used. In other words, the trustee will be held to take whatever legal estate is necessary to enable him to carry out the trust. Do you see what's going on, y'all? You see what we're going on? So the modern use of the word cestui, dealing with the modern term is cestui, was created by common recovery, which is fee simple. Contrasted entail, which denotes to the crown, which is crown land, which denotes to the English throne, which can only be personified by king and parliament, but the king is absent as a result of the interregnum, and that caused the state of the interregnum of the demise of the crown. All right, a transferring of the office, a transfer of the property, church property. All right, real property. All right. They're talking about cestui all through this case law. But when you read case law, when they mention the word cestui and you don't take it back to the origin of where it originated from, then you lost. You lost. All right? You got to take it back to the origin of the crown. Not the Church of England, Roman Catholic churches, you usurp the power of the crown. We know that through Henry VIII, all right, who put it in the trust. He took it from the Roman Catholic Church, going back to Augustine of Canterbury, to the Gregorian Reformation, to Pope Gregory I, who descended down from the Visigoths, the Lombards, and the Frankish dynasties, who made alliances with the Scottish kings, going back to the Scottish independence of 1295, with their independence between against Edward I, other plantations in the crown. All right? I don't need to understand what's going on. Let's go here. We already read what the Chief Justice said in Chisholm versus Georgia about corporations, all right? And the petitioner right for redress under the authority of the crown, under the king's royal prerogative. You can't petition the king if the king ain't there. And you can't get remedied by the king's judiciary, let alone judiciary ruling on the king's legislative authority if the king and parliament is not acting simultaneously by the fusion of power under the royal prerogative. All right, there is no justice then. All right, so let's read how justice is going to be brought back to the land. To the land. Let's read. It says, but this case does not go to the extent of holding that such legal title in case it had not been alienated, were passed to the successors of such trustees. In fact, in this aspect of the matter, we have found no case on all fours with the case at bar. It is, of course, well settled as a general rule that only natural or artificial person corporations can take title to land. Listen, y'all. Listen. Only two things people can take property. It just said natural or artificial persons. And there's only two types of corporations, sole and aggregate. All right? It's, of course, well settled as a general rule that only natural or artificial person corporations can take titles to land, and that unincorporated charitable or religious organizations cannot themselves take by deed title to land, and hence it is customary to convey to the officers or trustees and their successors for the use and the benefit of such organization, in which case such officers or trustees and their successors take and hold the legal title in trust with powers of an alienation. All right? So it's telling you that those who are not natural persons are custodians of the property, overseers of the property. All right? Overseers of the property. What this says right here. Here. But from the nature of a corporation, a conveyance to them will be understood as a fee without word limitation. And if it be a corporation, so it must be limited to such a corporator and his successors which is the case a corporation answers to heirs in the case of a grant to natural person or will be in the state only for the life of the corporator. Once again, let me just highlight that. Where was we at? I'm sorry, 1 second. Let's just highlight this right quick before we read it. All right, right here. Y'all gotta love your king for doing this magnificent work. All right. Now it said that the archdiocese and the Roman Catholic Church were unincorporated. All right. They were unincorporated, and it just said here, or was it down here? Yeah, down here. Only natural persons or artificial persons can take land, and that unincorporated charities or religious society cannot themselves take deed to title to land. All right? We're going to read it in its entirety now. Let's read it in its entirety. One reason, in common sense, we think this holding is correct. We find nothing in the books to the contrary. It is true that ordinarily an estate in fee simple is an estate of inheritance, one that will descend to the grantee's heirs if he died before alienation thereof. All right. But from the nature of corporations, a conveyance to them will be understood as fee without word limitations. And if it be a corporation so, it must be limited to such corporator and his successors, which is the case of corporations, answers to the heirs in cases of grants to natural persons, or it would be an estate only for the life of the corporator. All right. Most persons, natural and artificial, may be parties to a deed. The chief exception that the law has found have arisen from the disabilities of infants, persons, insane, or mentally incapable married women, aliens, and corporations. All right. But this case does not go to the extent of holding that such a legal title, in case it has not been alienated, will pass to the successors of such trustees. In fact, this aspect of the matter, we have found no case on all fours with the case at bar. It is, of course, well settled as a general rule that only natural or artificial person corporations can take title to lands, and that unincorporated charitable or religious organizations cannot themselves take by deed title to land. That means that the archdiocese under the Roman Catholic Church, going back to the Church of England under St. Augustine, under the Roman Catholic Church, cannot take the land. You couldn't take it then. You couldn't take it under Henry VIII when he put everything on a trust, right? Left for that individual to incorporate as a corporation soul, which is a natural person under the English Benedictine Reformation which existed in the time of King Edgar the Peaceful, which is our modern day Jesus Christ. All right. It says here that charitable religious organizations cannot themselves take deed to title of land, and hence it is customary to convey to their officers and trustees and their successors for the use and benefit of such organization, in which case such officers or trustees and successors take and hold the legal title and trust with powers of alienation. New Jersey Revised Statute 16.1-28. Right stated under the Charter of Great Britain, safe from appeal. An act to incorporate trustees of religious societies for properly held in corporations placed thereof. I'll close out on that in a second. If they can hold as such officers or trustees in succession the legal title for the unincorporated society, where the deed shows such a trust, why may they not be able to so take and hold for themselves in their official capacity, where the deed creates no express trust on behalf of the society, and yet show an unmistakable intention to convey them and their successors and their officials rather than their individuals' capacity? It may be that in such case, the grantee and such deed take neither as an individual only, nor as an artificial entity only, but partly in the nature of both the official position, which is quasi-corporate in its nature, being for the time incarnated in the man holding it and acting through him. Did y'all hear what that just said, y'all? Did y'all hear what that just said? It said, it may be that in such a case, the grantee and such deed take neither as an individual only, nor as an artificial entity only, but partly in the nature of both the official position, which is quasi-corporate in its nature, being for the time incarnated in the man holding it and acting through him. Y'all don't hear me. Y'all don't hear me. But this case does not, let me see, make sure. All right, let's go a little further. Both our Constitution and our statute provide means for the formation of corporations aggregate, but we find nothing either Constitution or statutes which either expressly or implicitly repeals the ancient common law institution of the corporation soul. Did you hear that? The first division of the corporation is into aggregate and soul. Corporation aggregate consists of many persons united together into one society and are kept up by a perpetual succession of members, so as to continue forever, of which kind are the mayor and commonalty of a city or governor, and head of the fellows of a college, the dean and the chapter of a cathedral church. Corporation soul consists of one person only and his successors in some particular station, which are incorporated by law in order to give them some legal capacity and advantages, particularly that of perpetuity, which in their natural persons they could not have. In this sense, the king is a soul, a corporation. So is a bishop, so are some deans and prebendaries, distinct from their several chapters, and so is every parson and vicar. And on page 472, he further says, but with us in England, the king consents is absolutely necessary to the erection of any corporation, either implicitly or expressly given. The king implied consent is to be found in corporations which exist by force of the common law, to which our former kings are supposed to have been given their concurrence. Common law being nothing else but custom, arising from the universal agreement of the whole community. Himself, all bishops, parsons, vicars, church wardens, and some others who by common law have ever been held, as far as our books can show us, have been corporations, virtuous officii. And this incorporation is so inseparably annexed to their offices that we cannot frame a complete legal idea of any of these persons. But we must also have an idea of a corporation capable of transmitting his rights to his successors at the same time. We find the following corporations are divided into aggregate and sole. A corporation sole consists of a single person who is made a body corporate in politics in order to give him some legal capacity and advantages, and especially that of perpetuity, which as a natural person he cannot have. A bishop, dean, parson, and vicar are given in the English books as instances of sole corporations, and they are their successors in perpetuity take the corporate property and privileges in word successors and generally as necessary for the successor of property in a corporation sole. As the word heirs is to create an estate of inheritance and a private individual. A fee will pass to a corporation aggregate without the word successors and a grant because it is a body which is in nature is perpetual, but as a general rule, a fee with no, but in general rule, a fee will not pass to a corporation sole without the word successor and will continue for the life only of the individual clause with a corporate character. There are very few points of corporation law applicable to a corporation sole. They cannot, according to the English law, take personal property in succession, and their corporate capacity in that respect is confined to real property. You hear that? Real property. It is true that the doctrine of the sole corporation has never received much recognition in America. However, it was held that a minister of the parish, sees of land, and right of parishes was a sole corporation. Chief Justice Shaw gives the interesting treatment of corporation sole as distinct from corporate aggregate. At the risk of unduly lengthening this opinion, we quote one paragraph. It becomes then necessary to consider what are the distinctions established by law between the sole and the aggregate corporation. The first and the most important is that corporation aggregate has a perpetual existence without change, so that an estate once vested in it continues vested without interruption. Whereas with a bishop or parson holding the state as a sole corporation dies or resigns his offices, the fee is in its abeyance until the successor is appointed. From this flows one necessary but obvious legal consequence, which is that a grant to an acting corporation carries a fee without the word successors, but a grant to a corporation sole without including successors carries a life estate only to the actual incumbent who is the first taker. The first taker. All right. Where is it at? Where is it? Okay. As you can see, the third typical English Church of England, king, heirs, and successors. How many have done that? How many have fulfilled a prophecy? All right. It's right there. All right. Let's give you another one. I have the right to do what I'm doing. All right. The incorporated right, the personifying right, the incarnated right. All right? I have this right. As you can see. Right there. Natural person. Corporation soul. Book and page number. Same instrument. All right? Right there. This is a corporation soul, royal peculiar, the crown. All right? A corporation soul, make sure you see this. I'll throw it right back in their face. A corporation soul, the legal entity consists of a single soul incorporated office occupied by a single natural person. This structure allows corporations, religious corporations, or commonwealth to pass without interruption from office holder to the next, given position legal continuity. Subsequent office holders will have an identical power of possession to their predecessors. All right? Pursuant to 16.1-28. Let me show you. I'm sorry. Right here. Saving rights under the charges granted by Great Britain. Being Section 12, an act to incorporate the trustee of religious society, incorporated April 9th, 1875. This section invested property held on the charges of incorporations, all right, granted by Great Britain and corporations created in place thereof, all right? So that's why I incorporated it as corporation soul. Let me take you to the statute right here. Is it here? 16, right here. 16.143-7, 8, and 9. We're going to read 9. Powers of consolidation corporate. The consolidated corporations have and may exercise all powers conferred by the respective certificate of corporation or charter. So a certificate of or charter has the same validity, frequency, power, authority, governance. All right, the same power it has. All right, and I'll close out on 16.1-28. I'm sorry for them being so long. I can't break this up in a couple of segments. All right. Saving rights under charters granted by Great Britain. An act to incorporate trustees of religious society. So this statutory law allowed the ability for the property of the English church to be transferred to the trustees of an incorporated English church pertaining to the certificate of incorporation known as the charter by way of the personification of the king holding the office as corporation soul representing the crown as a result of the English throne, which represents the protector and the holder of what we call church property under the Statute of Mortmain. All right? Because it said property held on the charters of incorporations granted by Great Britain and corporations created in place thereof. There's only two, aggregate and soul. The United States is a aggregate, and the English Temple Church is a soul. All right. You've seen it through our certificate of incorporation. All right. So I end on this. Uh, you know, they said in Johnson versus McIntosh, where's that? Public trust doctrine. Point one starts out with talking about James the First. All right. With the charges given to him by him as monarch to the proprietors as corporations, not corporations sold. Point one starts with 16 James, first king of England, his letter patent given out. All right. All the 13 colonies are accomplishing these points 1 through 11. All right. 1 through 11 encompasses the charges given about by James II to all the way up to Charles II. James I all the way to Charles II. All right. We're going to go up to 11. Read on your own time, but I'm closing out, so I want to get to my point. Ten. That on October 7th, 1763, all right, which was the Treaty of Paris, all right, going back to this case we just read, what was it, what's the case we just reading? Reed versus Barry, all right, in regards to the territory that was given to the archdiocese in lieu of what we call a fee and simple charter, conscious that which was entail left for the corporation sold, which they didn't represent because they were unincorporated. All right. It says here in Johnson versus McIntosh that from October 7th, 1763, the Kingdom of Great Britain, made and published the proclamation for the better regulation of the countries ceded to Great Britain by the Treaty of Paris, with the proclamation referred to and made part of the case. All right. It says 11, and from time immemorial, and always up to the present time, all the Indian tribes of the nation of North America, and especially the Illinois, Chickasaw, and all the other tribes held their land by way of just occupancy. They didn't own it. All right. And it goes into the Johnson versus the Martin versus Waddell. All right. But if you go right back here to this case, read, it was acquired a title from the archdiocese going back to what we said, time immemorial. Right here, time immemorial. All right, so understand what's going on, y'all. You know, so in closing, Johnson versus McIntyre make reference to time immemorial. This case, Reed L. Versus Barry, what was it? Reed L. versus Barry make reference to time immemorial. And we know time immemorial goes back to what we call the common law. In regards to property rights. In law, time immemorial, a period of time beyond which legal memory cannot go, time out of mind. Most frequently, the phrase time immemorial appears in legal term art and judicial discussions of common law developed in the United States the property rights of Native Americans. So it all had to deal with the right of property, real property, and the real property is the land, but not as Native Americans, but as English heirs and successors who now became Native American by the reclassification by those who were colonists who migrated here based off those colonists who usurped the throne of the English ancestors, going all the way back to the what we call the English Reformation under the Henry VIII. All right, through the usurpation, through the War of the Roses and the 100-Year Wars, going back to the Plantagenet crown, which automatically goes back to the unification of England and France through the Treaty of Westminster of 1153, through the Duchess of Normandy, which resulted from the Norman conquest of William the Conqueror, to Henry II, the son of Godfrey V, Count of Anjou. All right. All this goes back and covers feudal tenure, which is in question today, which they call free and simple, contrast to common recovery, which is common recovery, contrast to entail, which is land that's held by the crown for those heirs who are you, which I speak of today. So with that, I love you all, and I'll make sure I didn't miss anything. All right, let's see. Crown land is entail. All right. You see that? Crown land is entail. You got to go to court to get this matter resolved. All right. You have to go to court to get to the matter resolved in regards to who owns this estate, in regards to not just the land, but the property. You know what I'm saying? Which the house sits on. All right. Which is my father's house. And that father's house, you must be that of my noble family. So with that, I digress in this beautiful lecture. Sorry for it being so time consuming, but time waits for no man. All right. So with that, I close out. I love you all. With that, I say peace.